Good afternoon, everybody, and welcome to the first part of our two-part series, giving an overview of the ICO's draft direct marketing code. My name is Leonie Power. I'm a partner in the Privacy, Security and Information Law team here at Fieldfisher. With me is my colleague Camille Ebden, who is an associate in the same team. We specialise in all things data protection. And the aim of today is to give you some key takeaways from the draft direct marketing code. As I say, it's part one of two. So the second session next week will look at a number of different areas of the same code. To keep it simple, today we're going to focus on three main areas. Just moving on the slides, which aren't playing ball with me. There we go. So we're going to focus on three key areas. So firstly, we have an introduction from Camille. She will go over the status of the code and also some key definitions that are used throughout the code. And then we'll focus on three areas. Firstly, making sure that your direct marketing is lawful. And Camille will talk a little bit about finding the appropriate legal basis for the relevant direct marketing activity. And in particular, she will discuss whether that basis should be consent or legitimate interests. Then we'll look at leveraging technologies and what the code says about that, in particular focusing on carrying out a data protection impact assessment, the concept of privacy by design, and also some of the interesting 21st century technologies on which the code focuses, such as facial detection and facial recognition. And the third key area we will look at is online direct marketing considerations, in particular targeted advertising and the use of social media also for direct marketing purposes. So on that note, I will hand over to Camille, who will give you the intro to the code. Camille. I think you may be on mute, Camille. Apologies, I'm not sure whether we're having some technical issues as I don't hear Camille yet. Let me just check if she's having issues with her sound. Chloe, I'm not sure if you can hear me and whether Camille is having issues with her sound.
Hi, yes, I will just reconnect Camille if you just want to continue.
Okay, I'll continue on in the meantime. That's fine. I'll just continue with the intro then. Okay, so as the title suggests, the direct marketing code from the ICO is still currently in draft form. The consultation period for the code ended on the 4th of March, and the finalized version of the code is expected later in the year. It is a statutory code, so ultimately non-compliance with the final code will make it quite difficult to demonstrate compliance with the GDPR and PECA rules as they relate to direct marketing. The focus of the code is interesting insofar as it has a notable emphasis on 21st century marketing and profiling and enrichment practices. And there's much discussion around the use of social media for direct marketing purposes. There's also some discussions about whether it's possible to use facial recognition for direct marketing and or facial detection. And also some discussion around email tracking practices in a direct marketing context. So in other words, checking whether somebody has looked at or opened an email. The relevant legislation that's in play is, of course, not just the GDPR, but also the Data Protection Act 2018, insofar as it supplements and clarifies the GDPR, and also the e-privacy directive and the implementing legislation of that directive in the UK, the Privacy and Electronic Communications regulations. Okay, so moving on then to the next slide. In terms of definitions, obviously we need to establish what we mean by direct marketing. because the code applies essentially to anyone who is processing personal data for direct marketing purposes. Now, direct marketing is extremely widely defined. We can find a definition in section 122.5 of the Data Protection Act of 2018, and that refers to the communication by whatever means of advertising or marketing material which is directed to particular individuals. So as long as the material is directed to particular individuals, then you're in the realm of dealing with direct marketing. So it isn't just marketing in the sense of an email or an SMS. It also includes, for example, behavior targeted advertising, because again, that is advertising that is directed to a particular individual based on profile being built about that particular individual. And that's something that isn't always appreciated by advertisers, and it's been made clear within the draft direct marketing code. Of course, that will have implications such as the right to object will kick in, because some of you may be aware of the fact that there is an absolute right to object to direct marketing within the GDPR. The other interesting point about the definition of direct marketing purposes, or what we mean by direct marketing purposes, because it's not defined as such within the GDPR or PECR, but the code explains what's meant by the term direct marketing purposes. And it says, interestingly, that it includes all of the processing activities leading up to and supporting the sending of the direct marketing. So it's not just the direct marketing email itself. So the code essentially applies to any processing of personal data with the intention that it is used to communicate a direct marketing message to somebody. And that's the case whether or not it's you or somebody else that's going to be carrying out the direct marketing. And so, as I've said, the implications of that are that an individual has an absolute right to object to processing for direct marketing purposes. So individuals have an absolute right essentially to opt out of the direct marketing communications and also of the profiling activities that support those communications. So the data cleansing, the matching, the screening that's going on behind the scenes. And in fact, that is made clear within the GDPR itself. So in the context of the right to object to direct marketing purposes, reference is made to opting out not only of the direct marketing, but also of the profiling that's being undertaken for direct marketing purposes. Okay, so that was the introductory section, and we've covered off the status of the code, and we've covered off some basic definitions of what we mean by direct marketing, which we saw was very widely defined, and we talked about direct marketing purposes. So we now come to the one of the substantive areas of today's presentation, which is around making sure that your direct marketing is lawful. And in order to do that, you need to have an appropriate legal basis to undertake your direct marketing activity. Now, generally speaking, that's going to be one of two legal bases. It's either going to be consent. In other words, you have the consent of the relevant individual to undertake the direct marketing activity, or it will be that the direct marketing activity is in your or a third party's legitimate interests, and those interests are not outweighed by any prejudice to the rights and freedoms of the relevant individual or data subject. And so, one of the key things to think about in this context is, well, can you rely on legitimate interests for the relevant direct marketing activity? And the GDPR in itself makes clear that reliance on legitimate interest is a possibility in terms of engaging in direct marketing activity. However, we then need to think about the interplay between the GDPR on the one hand and the PECR rules on the other hand. And in that context, essentially, the specific rule trumps the general rule, or as they say in Latin, lex specialis applies. So we need to look at whether there's a specific rule which applies under PECR to the relevant direct marketing activities. So if, for example, you're sending out direct marketing by email, the starting point is that you need prior consent in order to do that, unless you're relying on what's called the soft opt-in exemption, which is quite narrowly construed. But generally speaking, you need prior consent in order to engage in email marketing for PECR purposes. And so there's a specific rule about that type of marketing. Now, obviously, if you engage in some kind of email marketing, you're going to be processing personal data. Inevitably, you will be processing an email address, for example. And so the GDPR rules are also engaged, which means that you must have a lawful basis to undertake the relevant processing. Now, if the specific rule for PECR purposes is that you need consent, because the specific rule trumps the general rule that you need an appropriate legal basis, then the specific rule prevails. In other words, you also need consent for GDPR purposes, or consent is the most appropriate legal basis for GDPR purposes. And that's why you would use consent for that particular type of direct marketing in order to satisfy both the GDPR and the PECR rules. However, for other types of marketing where there isn't a specific rule, then it may be possible to rely on legitimate interests for the personal data processing. So, for example, PECR doesn't have any rules about mail marketing, for example. And so from that perspective, yes, you will still be processing personal data. There's no specific rule as such, but you do need to have a legal basis for processing the relevant personal data. And so from that perspective, it is legitimate, or it is possible to rely on the legitimate interest ground, as long as, of course, you satisfy other GDPR principles, such as transparency, that you've been upfront with individuals about the possibility that you will use their mailing address in order to send them marketing information, for example, and providing the usual information like the identity of the data controller and other information that's required by Articles 13 and 14 of the GDPR. So, you know, all of this is made clear within the code, that you need to identify the appropriate legal basis for processing, and that PECR rules in some cases may be engaged, which will dictate the basis on which you're processing personal data. Okay, so continuing then with lawfulness, assuming that you do need to consent for GDPR purposes, Article 94 of the GDPR makes clear that wherever there's a reference to the European Data Protection Directive in any European legislation, that should be deemed to be replaced by a reference to the GDPR. Now, within the PECR rules, essentially when those rules talk about consent, they define consent by reference to the previous European Data Protection Directive. And so that reference is now deemed replaced by a reference to the GDPR, which essentially means that when you are seeking to establish that you have a consent to the relevant direct marketing, you've got to show that you've got a consent that meets GDPR standards. So what do we mean by GDPR standards? Well, Article 411 of the GDPR defines essentially what is meant by consent. Consent must be freely given, and I'll talk a little bit later about what we mean by freely given and whether, for example, you can have a cookie wall, which means that you require individuals to give their consent to direct marketing in order to provide a service. So freely given must mean essentially that there's no, there's no undue pressure on the individual to give their consent. It must also be specific and informed. So again, that boils down to having an appropriate level of transparency in terms of how personal data will be used. And there must be some kind of unambiguous indication of the individual's wishes. And so an individual must take a deliberate and specific action to agree to the direct marketing purpose. And what is absolutely clear in this context is that you can't use pre-tick boxes or rely on any kind of silence or inactivity. That said, as long as there is some kind of unambiguous indication, it doesn't necessarily have to be a tick box scenario. It could be, for example, that you have a statement that says, by filling in your email address below and pressing the submit button, you hereby consent to ABC Limited sending you marketing by email for goods and services in which you may be interested. clearly by putting in your email address and pressing the submit button, there's an unambiguous indication of your consent to that particular direct marketing activity. So there needs to be some kind of affirmative and unambiguous indication. It doesn't necessarily have to be a tick box, whereby you invite people to tick a box to indicate their consent, but that is, of course, one way of doing it. And of course, the other point about the Article 411, in terms of the consent and the nature of that consent, it's clear that it must be as easy to withdraw consent as it is to give it. And obviously, if an individual withdraws consent, then you should cease the relevant processing to which that consent relates. Okay, I have a few questions. This actually might be a good place. Let me just check if I finished the lawfulness angle. Let me just finish out the special category point of the code, and then I'll cover some of the questions. Okay, so the code says some interesting things in relation to special category data. It makes clear, and of course, just by way of reminder, when we talk about special category data, we're talking about information relating to race or ethnic origin, political opinions, religious beliefs, data concerning health or sex life or sexual orientation. And the code reminds us that in order to use special category data for direct marketing purpose, you must, of course, meet a special category condition as per Article 9 of the GDPR, or it may be that a member state might have implemented further specific conditions. But in other words, you've got to meet a condition for processing that data. And in practice, and at least the code makes clear, the only condition available for processing special category data for direct marketing purposes in the UK is essentially explicit consent. Now, explicit consent is not defined in the GDPR, but the additional requirements are likely to be, that there's some sort of clear statement orally in writing, and it should specify the nature of the special category data, and it should be separate from other consents. And one way that I like to describe the difference between a consent and an explicit consent is, a scenario where I'm bringing my car to the mechanic, and I go along to the mechanic, and I say, and he or she says to me, can you hand me your telephone number, and I'll give you a call when the car is done. And in the full knowledge that that's what my telephone number is going to be used for, I hand it over. So clearly there's an affirmative action there. I'm clear about what the data is going to be used for. The affirmative action is in the form of me handing, the telephone number over. So there's clearly an affirmative action. So there's arguably consent in that scenario. What I'm not doing is, signing and ticking a box, signing a statement saying, I hereby consent to you using my telephone number to call me when my car is done, tick the box, which is more in the realm of an explicit consent. But further guidance on what's meant by explicit consent can be found on the ICO's website. Now, one of the interesting points that's made clear within the code is that having information about the nature of the products you sell in itself doesn't amount to sensitive data. So, for example, if you had a list of customers that bought a hearing aid, that in itself wouldn't amount to special category data unless you used it to infer special category data and to direct market to those individuals on that basis. So that is a helpful clarification. So unless you are processing data about that person's specific condition, or you're inferring that they have a special condition, then just having a customer list next to a list of products in itself won't mean that you're processing special category data. So as I say, that's quite a helpful clarification in that regard. Okay, so that has dealt with lawfulness. So there are quite a number of questions, so let me just quickly check. I think I should be able to scroll back up to those. Do we think that the code goes further than the law? I think the code, clarifies how the law is likely to be interpreted. So I guess it goes further than the law insofar as it does also recommend good practice. Yeah, I guess to that extent, it goes further than the law because it suggests things that aren't, within the GDPR per se. And obviously at the end of the day, guidance is not black letter law. So there's always some room for maneuver in that respect. But at the same time, given its status as a statutory code, it will be quite difficult to demonstrate compliance if you show that you're if you're acting contrary to the guidance that's produced within the code. So someone's asked about the future of the GDPR in the UK after Brexit. Well, the GDPR, as it is currently part of UK law, and it will stay that way in the form of, it has essentially been adopted into UK law or supplemented or recognised by the UK Data Protection Act 2018. The UK Data Protection Act 2018 will continue on the books post-Brexit. And in addition, the idea is that there will be legislation as at the 1st of January 2021, which is essentially will import all of European law into UK domestic law, subject to parliamentary tweaks. Obviously, there will be parts of the GDPR that obviously will not be relevant insofar as the entire Chapter 5, for example, of the GDPR is to do with the interaction between supervisory authorities and the role of the EDPB, etc., etc. And so that won't be relevant for UK law domestic purposes. And so, the necessary tweaks that's envisaged will be by virtue of, parliamentary tweaks through the, so-called Henry VIII powers that Parliament can make post-Brexit. But essentially, GDPR, as we know it, will continue on the books. It may be that down the line it will start to diverge, but at least the starting point will be it will continue, as we know it. In what instances do the PECR regulations apply? Generally speaking, the PECR regulations for direct marketing purposes apply to email marketing. They also apply to automated calling and certain, so live telephone recordings, so certain types of direct marketing, live telephone calls rather. So in terms of the rules, generally speaking, you need prior consent to email marketing unless you can avail of the soft opt-out exemption. For live telephone calls, you can't engage in direct marketing by telephone if someone has essentially registered with the telephone preference service. You can only override that registration if you have a specific consent to do so. In practice, what organizations do is they will check their own suppression lists and they will check the TPS to see whether or not an individual is registered, and if they are, then they generally won't be marketing to them. So they'll take that approach rather than seek to override that registration with a specific consent. What if cookies are placed for the purposes of processing data for non-electronic marketing purposes? Is explicit consent still required? Well, if you're using any cookies, and we'll come to this a bit later because I will deal with the use of cookies within emails to track email marketing. But if you are using cookies, you do need consent to use cookies, and you need prior consent to use cookies, except in very limited situations. So we'll see how that has an impact in the context of email marketing when I come to that section. Okay, so I'll leave the questions there for now and just move on to the second part of the talk. So far we've dealt with, ensuring that your direct marketing is lawful, and we talked about identifying an appropriate legal basis for your direct marketing activity, and also if you are inferring some kind of special category data, then you do need to comply with the sensitive data condition. And the only real, in practice, the only likely one you'll be able to use is the explicit consent of the individual. In terms of then the second section of the talk, we wanted to just briefly touch on what the code says about leveraging new technologies. And in particular, the code makes clear that if you are using new technologies for marketing and online advertising, it is highly likely that you'll require a data protection impact assessment. And the code reminds us that DPIAs essentially are there to help you analyze your processing activity and also to identify and minimize data protection risks when you're processing personal data. They are a legal requirement when the processing is likely to be high risk to the rights and freedoms of individuals. And the ICO has compiled a list of processing activities where they say that a DPIA is required. And the code outlines those activities insofar as they're relevant to direct marketing. So the ICO list that triggers the need to carry out a DPIA includes, for example, large-scale profiling, data matching, invisible processing, so that could include list brokering, online tracking by third parties, online advertising, and reuse of publicly available data, tracking the geolocation data or behavior of individuals, and also targeting children or other vulnerable individuals for marketing and profiling. Now, some of these processing operations will require a DPIA automatically. Others will require a DPIA if they occur in combination with any of the other criterion from the European guidelines on data protection impact assessments, and there's 9 of those criteria that may act as indicators of likely high risk processing. So if your direct marketing activity includes processing of a type that is likely to result in high risk, you must do a DPIA before you begin the processing. And also, they shouldn't be viewed as static. They should be reviewed periodically. And again, the code makes this clear to ensure that they accurately assess the processing, and also they continue to assess the risks and the mitigations that are in place with respect to those risks. So some reminders around the need to carry out a DPIA within the code. The code also touches on data protection by design as it relates to direct marketing activities. It reminds us that accountability is a key principle of the GDPR and that you must be able to demonstrate that your direct marketing practices are compliant with the GDPR. So there is some practical guidance within the code on how to achieve accountability obligations. So in other words, carrying out a DPIA where legally required to do so, reminding us about the need for a GDPR compliant contract with processors. So for example, if you're using a processor to screen a marketing list against a telephone preference service, reminding us about taking a data protection by design approach. And what do we mean by taking, or at least what does the code remind us that we mean by taking a data protection by design approach? Well, that's about considering the data protection and privacy issues up front when you're planning your direct marketing activities. So making sure up front that you have in place appropriate technical and organizational measures to implement the data protection principles and to safeguard the rights of individuals. Now, in terms of data protection by design, the code sets out certain data protection issues that must be considered. So you should consider who your target audience is. Obviously, things like, if you're targeting children or vulnerable individuals, that will be a key issue to address. Are you a controller or are you joint controller? And we'll see in a few minutes about how in some situations in a social media marketing context, you may be deemed to be a joint controller. How will you ensure that the marketing is lawful, fair, and transparent? What purposes are you collecting the data for? What data is necessary? Are you going beyond what's proportionate? How long do you keep the data for? How will you ensure the data is secure? And will any data be transferred overseas? And so the code again reminds us that thinking about these things from a privacy by design perspective will help ensure that your direct marketing is in compliance with the GDPR. The draft code also says some interesting things about the buying process when you're buying in new technologies. First of all, it suggests that you ask yourself whether you're clear about the capabilities and functions of the technologies. Are you clear about what the technology can do and that you're comfortable with what it does in practice or what it's able to do or what your staff will be able to do with the technology? Have you asked questions around the data protection by design approach. So was a data protection by design approach taken when the technology or the service was developed? Was a data protection impact assessment undertaken? Now, from a manufacturer's point of view, you know, it's unlikely that they will be mandated to carry out a DPIA because they're essentially selling the tool or the software or the technology. They won't necessarily be using it to carry out the relevant processing. That said, it's likely to still be good practice from a manufacturer's point of view, and may also serve as a selling point to customers if, as a manufacturer, you're able to say, you know, we've taken a privacy by design approach, and as part of doing that, we've carried out a data protection impact assessment. So the draft code points out the advantages of manufacturers undertaking a DPIA. From a purchaser's perspective, you know, the code again makes clear that purchasers may be required to carry out their own DPIAs. Obviously, to the extent that the purchasers of the technology are going to be using, for example, or processing any special category data, again, they need to consider how they do that in a lawful way. So overall, the code makes clear that purchasers of these technologies must be satisfied that the use of these technologies meets the requirements of e-privacy rules and also the GDPR, and it's not enough to rely on a contractual assurance to that effect from, you know, the seller or the vendor of the technologies. Okay, so still on the topic of leveraging technologies, the code again makes clear you know, some of the rules that apply in relation to the use of location data. So the code points out that the e-privacy rules on location data don't apply to GPS data or to location information that's collected at a purely local level. So for example, if there's Wi-Fi equipment installed on businesses offering, you know, Wi-Fi on their premises, and that's collecting some kind of location information, generally speaking, that type of use of location information won't engage e-privacy rules. However, it will engage GDPR rules. And obviously from that perspective, organizations need to be transparent about any location-based marketing techniques in which they're engaging. It's likely that such organizations would need consent in those circumstances. Again, you know, not because there's some kind of e-privacy rule, but because if we think about what is the appropriate legal basis, we can conclude that it's very unlikely to be in people's reasonable expectations that, you know, you would track their location in order to send adverts to them. So it's going to be really difficult to rely on the legitimate interest ground in order to engage in that type of direct marketing activity. So the code suggests, therefore, that you would need consent for that type of direct marketing activity. So the use of location data in order to serve ads. The other interesting point, and you know, it's coming up increasingly as something that data subjects are becoming more aware of, is the use of tracking pixels within direct marketing emails. And if you are engaging in direct marketing by email and you are using these tracking pixels, then GDPR rules and PECR rules will apply to the sending of the direct marketing email itself. But in terms of the use of the tracking pixel within the email, the cookie consent rules will apply to the extent that you are storing information on a device or accessing information on the device that's used to read the email. So you do need to be careful if you are engaging in these kinds of email tracking activities. And one of the challenges, of course, in this context is, well, how do you get that upfront consent to the use of cookies? Because it'll be very difficult to get specific and informed consent that's sufficiently granular and separate in order to satisfy the GDPR rules in relation to obtaining consent. So query whether you need to think about, as well as having your email consent box, you know, saying, do you agree to, you know, receiving direct marketing emails, that you have a separate box that says, you know, are you happy to be tracked? But, you know, this isn't being done as standard. We're not seeing that that organizations are taking that approach as yet, or at least I haven't come across that. It may be that they're taking a different approach or obtaining consent by some other means, but we are seeing an increased awareness among users of the use of these tracking pixels. So the code specifically addresses that. Let me see, I think I will continue to the end of the technology section. And I just have one more slide on that, and I'll take a few more questions, and then we'll deal with the last section. Okay, so still dealing with leveraging new technologies then, the code looks at the use of, or the potential use of, facial recognition and facial detection technologies for direct marketing purposes. And the code distinguishes between facial recognition, which is seeking to identify or verify a specific individual, and facial detection, which seeks to distinguish between different categories of individual. And the draft code makes clear that it's unlikely you will be able to use facial recognition technology to display direct marketing to specific individuals. And I always think in this context of that film Minority Report, where Tom Cruise walks into the mall and he gets, all of these billboards saying, "Hey Tom, welcome to our store, and are you interested in whatever it is that they think you might be interested in?" So clearly the code envisages that that kind of direct marketing is very unlikely to be possible, because of the difficulty of complying with lawfulness and fairness and transparency requirements. And the code also makes clear in that situation that it's very likely that you would need some kind of explicit consent, because you are processing special category biometric data. And so if you think back to the definition of special category data, we see that it includes biometric data to the extent that it's uniquely identifying an individual, or that it's used to uniquely identify individuals. And so to the extent that you are seeking to use that kind of technology, you're going to need explicit consent. And so it's going to be quite challenging to address those requirements around explicit consent, lawfulness, fairness, and transparency. So the code, envisages it's unlikely that you'll be able to use facial recognition for direct marketing purposes. However, the news is a bit better from a marketer's perspective in the context of facial detection. As we've said, facial detection seeks to distinguish between different categories of individuals. So if you wanted to segment audiences in a particular shopping center, for example, into different categories using facial detection and market on that basis on the various billboards that were displayed, then it might be possible to do that. And the code does make that clear. But it does sound a warning note insofar as it says you need to be careful to ensure there's no scope creep. Because if by doing that you start tracking an individual across a particular area of the shopping mall, such that you could be said to be singling them out, then you will be into the realm then of making it more difficult to comply with GDPR requirements. So you must ensure there's no scope creep, and of course, ensure general compliance with the principles of the GDPR. So some really interesting discussion there around use of some of these new 21st century technologies. Okay, I'll pause on that note. We only have about 5, actually maybe I won't, because we have about 5 minutes left, and I'd quite like to cover the social media stuff. So I'll continue. If there's time at the end, I don't think there's anything on immediately after this. So if you have time to stay on, then we can deal with some of the questions. So the third area that we wanted to deal with today was online direct marketing, and we again looked at the code insofar as it applies to behavioral targeted advertising. And as I've said, behavioral targeted advertising falls squarely within the definition of direct marketing. So the code makes that absolutely clear. And as a result of that, individuals have an absolute right to opt out of behavioral targeted advertising, including the profiling that goes on behind the scenes. The code distinguishes between behavioral targeted advertising and contextual advertising. So contextual advertising being the scenario where the advertising is targeted to the contextual features of the particular page, so the content of the page. And the code says that that's not direct marketing because it's not directed to a particular individual. However, that conclusion does appear to be premised on the assumption that personal data is not being processed for ad targeting. And so the draft code doesn't appear to consider, well, what if personal data is being used for frequency capping? In other words, in a contextual advertising context, ensuring that those contextual ads are only targeted at individuals who haven't seen them before. So to that extent, there may be some limited personal data processing. And so the status of those types of ads is not entirely clear. And it may be that the finalized version of the code would address that particular point. The code also makes a throwaway reference to push notifications. It briefly talks about them being caught by e-privacy rules, which is quite interesting because if we look at the definition of electronic mail within the e-privacy legislation, it seems to envisage some kind of message that can be stored and later retrieved. So it's not entirely clear what the code means by push notifications and whether it actually had envisaged that it's the type of notifications that can be stored and later retrieved, because that would seem to be the criteria for triggering the application of PECR. Again, that may be something that will be clarified within the next version of the code. Oh, sorry, I forgot to move the slide on there, and as I talked to the wrong one, but all it had was just some of the bullet points in any event. So just exactly the point that behavioral advertising constitutes direct marketing. Contextual advertising, the code says doesn't, but they don't seem to have considered frequency capping, and just that last point about push notifications. Moving on then to the next slide about putting up direct marketing walls, the code makes clear that it's very unlikely that you can make access to a service or a benefit conditional upon to agreeing to receive direct marketing. So it does seem to outlaw cookie walls. However, it does seem to say that you can incentivize individuals to sign up to direct marketing. And so it gives some examples of that. I guess it would be a case of making sure that you don't cross that particular line in terms of unfairly penalizing people that don't sign up. The code makes clear in terms of cookie walls that, as I say, generally it should not be done, where the direct marketing is not necessary for the performance of the service. And it gives the example of a train company only allowing access to free Wi-Fi if passengers consent to receive direct marketing. And it says that that consent is not valid because collecting details for direct marketing is not necessary to provide the Wi-Fi. But interestingly, the code says that there are some limited exceptions. So if the whole purpose of signing up to a retail loyalty scheme is to receive marketing offers, then it does seem to envisage that would be possible. And as I said, it does also envisage that you can incentivize individuals, such as by giving them discounted products or access to special offers if they agree to direct marketing. But it says you can't unfairly penalize people who don't sign up to receive marketing. So, for example, you can't prevent a person from collecting loyalty scheme points to redeem against future purchases if they don't consent to receiving marketing messages. So some interesting analysis within the code about what's acceptable and what's not from a cookie wall perspective. Also some very interesting commentary on the use of social media for direct marketing purposes. The code makes clear that using list-based tools such as Facebook custom audiences or LinkedIn contact targeting to display direct marketing to users of those platforms is likely to require user consent. So that consent would be the appropriate legal basis for the relevant data processing, which is an interesting point. It also makes the point that if you're using or if you're providing personal data to social media platforms to create lookalike audiences for targeted marketing purposes, then you're likely to be acting as a joint controller with that social media provider in relation to those lookalike audiences. And it would be incumbent upon you as part of your Article 26 of the GDPR requirements to ensure that there's some kind of an arrangement between you that sets out your respective responsibilities and ensure that transparency requirements, for example, are addressed. So you would need to ensure that you're transparent with the original audience and that the platform is transparent with the lookalike audience in terms of the processing that's being undertaken. The key point here is that even though as an organization you might not have access to the data relating to the lookalike audience, you have the ability to influence the processing of that data. And so from that perspective, you would be considered to be a joint controller. And this is in line with the Fashion ID decision, which I will very briefly touch on now on the next slide. Very briefly, this decision was a decision of the Court of Justice of the EU, handed down on the 19th of December 2018. It concerned an online fashion retailer, Fashion ID, and essentially they embedded a social plugin, so the Facebook like button in that case, whereby when a user encountered the website, data was automatically sent to Facebook. Now, the Fashion ID, so the website operator, did not have any visibility over the data that was being sent. But nevertheless, the court held that the website operator in that case was a joint controller with Facebook in terms of the collection and the transmission of the data to Facebook. Now, interestingly, it said that the website owner was not a joint controller in respect of the subsequent processing by Facebook, but at least in respect of the collection and transmission, it was a joint controller and it was responsible for providing appropriate transparency information to users. The practical implications of that, of course, is that we're likely to need to think about joint controllership arrangements and data sharing agreements more frequently to ensure that there's an arrangement between joint controllers, particularly in an ad tech context, and also making sure that for the second controller who receives the data and wants to do data processing down the chain, that they need to make sure that they have an appropriate legal basis and that the website operator obtains or facilitates getting the necessary consent or providing the necessary transparency information in order to allow the subsequent uses downstream by the recipient of that data. So some interesting practical implications of that particular decision, and as I say, it's followed through in the draft direct marketing code. Okay, so that was a bit of a whistle-stop tour. The code is quite extensive, and so that's why we chose to focus on just 3 areas in today's session. The next session will be on the 14th of July at 15:45 with my colleague Nuria and my colleague Camille. So hopefully you'll be able to hear from Camille then. And that session will cover other topics within the draft code because, as I say, it's quite extensive. So I hope that's been useful. As I said, we've covered 3 areas, making sure that your direct marketing is lawful, so finding an appropriate legal basis, leveraging new technologies, the need to carry out DPIAS and ensure privacy by design and by default, and also having appropriate due diligence around the buying process and understanding the do's and don'ts in the context of some of the more 21st century technologies such as facial recognition and facial detection, and then finally looking at direct marketing online, how behavioral targeting is squarely caught, and how you need to think about GDPR in the context of your interaction with social media platforms if you are engaging in social media marketing. So I really hope that was useful. For those of you who do have 5 minutes, I'm conscious that we are at time, but I'll perhaps deal with 1 or 2 of the questions, and if there are any outstanding ones, I'm happy for to deal with them in a follow-up if you want to email me. My email details are on the slide. There's one, straightforward one. Will the slides be available? Yes, they will. In fact, the recording will be available, will be circulated by our marketing team. Okay, interesting question around reasonable expectations of individuals and whether that might change over time. Certainly, I think the argument could be made that that's the case as users become more increasingly familiar with what's likely to happen to their data and what technologies can do, and it becomes run of the mill. Then there certainly could be arguments around what's within someone's reasonable expectation, and whether from that perspective you might be able to rely on LIA. So I totally would envisage that things could change over time, and that, you know, what might be considered, you know, extremely invasive and outside someone's reasonable expectations today might well be a run-of-the-mill and expected practice in, you know, in due course. But I think it's about, in that situation, if you're looking to make that argument, having your legitimate interest assessment along the lines of having some kind of variation of the ICO's template to justify your position in terms of reliance on legitimate interest. Email tracking and generally campaign measurement, can we rely on the fact that there is further processing which is compatible with the original purpose? I would distinguish there between the processing of personal data and whether you can rely on you know, it being compatible with the original purpose, and the specific cookie rules set out within Pecker, because there's a specific rule in Pecker that if you drop a cookie, in other words, if you access information on a device or store information on a device, then you need consent, except in very narrowly construed exceptional situations. So if that's the case, then it won't really help you to make that, you know, analysis in terms of the compatibility with the original purpose. And in fact, then in terms of the exceptions to the rule on direct marketing of your own products or services, the consumer has already subscribed or bought the service. No explicit, that is a reference to the soft opt-in exemption. So in those exceptional situations, you don't need prior consent to email marketing, but you do need to meet the relevant requirements of the soft opt-in exemption, such as that you've provided an opt-out at the time of collection of the details and in every subsequent market communication, that you've obtained the details in the course of a sale or in the UK negotiations for a sale, that the subsequent marketing is of similar goods and services by the same organisation. So there are a number of hurdles to meet, but if you do meet those hurdles, then indeed you can rely on the soft opt-in exemption. I think we've covered the question about the legal basis for lookalike audiences. The code does suggest that if you are marketing on social media, that the appropriate basis is likely to be consent. What constitutes large scale in terms of DPIA? For more information on large scale processing, it's really useful to look at the EDPB guidance on carrying out DPIAs, because they do go into more detail on that. And certainly in other EDPB guidances, there's discussion around what's meant by large-scale processing as well. In terms of enforcement, what kind of enforcement the code will have, you know, that's likely to be tied into GDPR enforcement. So the code is basically guidance on how to comply with the GDPR and to demonstrate compliance with the GDPR. So as I say, if you don't follow it, then it's going to be difficult to demonstrate that compliance. And so all of the enforcement options that are available to the ICO under the GDPR would be available in that particular context. And I think, have I covered them? Okay, so direct marketing. Yeah, I think we probably need to wrap it up there. I'm sorry, we've run out of time. There were a couple of other questions, but as I say, feel free to email me if you would like me to follow up. I hope you've enjoyed today's session and that you can tune in to the session next week. I'd also flag that my colleague Renzo is doing a SHREM session at 4 o'clock next Friday. So it's all happening on the data protection front. Never a dull moment. So thank you very much for your attention. I hope you've enjoyed the session. Thank you.